It's always challenging to go in the session right after lunch on the third day because, of course, everyone's energy is starting to plummet and you're digesting, so the blood is rushing away from your head and you're falling asleep. I will try to be engaging and keep you awake, but I would also hope that you've caffeinated. So my task in a brief period of time, as I understand it, is to... Is there an issue? No. Is to give you an overview from one particular jurisdiction of how jurisprudence has developed, and in the course of doing that, specifically jurisprudence on HIV criminalization. And in the course of that, I think it will illustrate a few things that are instructive for not only our advocacy in our setting, but may be useful for advocates in other settings. So let me give you the quick whirlwind overview of the state of HIV criminalization and the law in Canada, and how it's been applied so far. And I think this is perhaps worth sharing because, as I mentioned in an earlier presentation, Canada is actually one of the countries in the world that has one of the largest absolute numbers of prosecutions. I think we're third in the world now, if I'm correct, after the US and Russia. Oh, we're fourth. Okay, well, we're happy to be losing, well, sort of happy, not happy, I guess, that someone is doing worse than we are. Who's the? Belarus. Okay, so US, Russia, Belarus, and then Canada in terms of absolute numbers. So what happens in those countries with a lot of prosecutions also tends to mean a lot of developments in the jurisprudence and also potentially broader ripple effects in other jurisdictions. And in the case of Canada, I just want to give you the briefest, bare bones understanding of the legal context in which HIV criminalization has arisen, because one thing that's clear from all of our discussions at this meeting is that the system, the context in which this issue emerges or to which it is grafted really matters about how the parameters of HIV criminalization evolve. So in our context, we have a federal criminal code, so that is one criminal code adopted by the federal parliament that applies throughout the country, at least on paper, but in a quirk of history, because of how powers have been divided in our federal state, it is actually provincial governments, of which there are 10, that are charged with the responsibility of actually administering the criminal law, even though the substantive criminal law is actually adopted by the federal parliament. And there are 3 territories in the north who have a slightly different legal status given the way our history has evolved. And in those territories, it is actually the federal government that has the lead on prosecuting charges under the criminal code. And this is relevant for something that I will come to later, which is why I mention it. It's also relevant, of course, to where we target our advocacy and our interventions. Now, in that federal criminal code, there is no HIV-specific offense. There used to be, some decades ago, a section on spreading venereal disease. That was the language used in the code at the time, which was actually primarily legislation inherited from the British back during the colonial era. And that provision had just been carried forward since the late 1800s and had remained in the criminal code, but virtually unused with a couple of, actually with no exception, if I recall. And that was part of the reason that it was repealed in 1985. Of course, this is in the early years of the HIV epidemic, and that reality hadn't yet influenced the discussion. And so this provision, as part of a much larger exercise of criminal code modernization, I should mention, was repealed. And partly because it hadn't been used, and partly because this issue was seen primarily as a matter of public health rather than of criminal justice. So what has happened instead is that HIV criminalization has taken form not through the adoption of a particular statutory provision singling out HIV or potentially HIV and other sexually transmitted infections, but has arisen through prosecutorial resort to and judicial interpretation of other provisions in our criminal code, provisions of general application that prosecutors and the courts have sought to adapt to the situation of HIV transmission or exposure, as we will see, non-disclosure. And I've listed here 5 of the offenses that are in our criminal code, that are crimes in Canadian law, that have been used to varying degrees over the years to prosecute someone living with HIV for exposing a sexual partner, primarily they've been sexual non-disclosure cases as opposed to others, to the risk of acquiring HIV, or have had a sexual relationship and the complainant has become HIV positive. Whether as a result of that encounter or not is, of course, a separate question. So you see that the offense of poisoning, basically, administering a noxious thing, has been used on a few occasions. The offense of common nuisance, that is being a common nuisance, creating a danger to the health or safety of others. The offense of criminal negligence, causing bodily harm. There have been attempted murder charges, few, but it has happened. The offense, however, that has been used most often is the offense of aggravated sexual assault, and that's why it's in red here, and that's what I'm going to turn to in a moment. But the fact that there are these other provisions in the criminal code and that they have been used on occasion, with mixed results, I should say, is something that we need to keep in mind in how we approach our advocacy challenge of limiting HIV criminalization appropriately in Canada, and I'll come back to that later. So if aggravated sexual assault is the crime that has been used most often to deal with HIV, to criminalize HIV, the key case that confirms that this is an applicable charge in Canadian criminal law and that has really set the frame for all the discussion in the last 20 years is a case called Courier. I know it's a French word and it should be pronounced Courrier, but it's actually pronounced Courier. It's just a funny Canadian thing. And that went up to our Supreme Court in the late 90s, and it was a case that actually originated in the early 90s, but it took 6 years to make its way up to the Supreme Court. And this is the key part of what the court said. And this was the first time our Supreme Court was actually called upon to address this issue of HIV criminalization. And the two lower courts below, the trial court and then the Court of Appeal for the province of British Columbia, where this case originated, had actually rejected, as a matter of law, that the prosecution could get a conviction for assault based on not disclosing your HIV positive status. They rejected those arguments. There had been other cases where prosecutors had been successful. So there were these conflicting decisions at lower courts, which is one of the reasons that the Supreme Court agreed to hear this case, because part of its function is to resolve contradictory jurisprudence and provide guidance for the country as a whole in setting out the law. And the law that they set out in this case, I've summarized here on the slide. They turned our offense of assault in our criminal code is defined as including various branches or elements. And an assault is just a physical contact between a person and another person without that person's consent. That's the basic crime of assault. And it can be the most minor of contact to the most egregious and serious and violent of contact. But physical contact with another person without their consent is an assault. So then the question becomes, well, when is there consent and when is there not consent to that physical contact? In the sexual context, obviously, it's the sexual encounter. And one of the things that can, in our law, mean that there is no consent to a physical contact is fraud. So it's not just that you apply force to someone else, which they're not consenting to, or that someone consents to sex because they're threatened or they're afraid, which are clearly the sorts of things that we understand quite properly as being sexual assault. But our law also says fraud can invalidate someone's consent to sex. So if I obtain my sexual partner's consent to sex through fraud, then that consent is not legally valid. It is invalidated retroactively, and therefore it becomes a sexual assault by law. So the question for the court then was to say, well, how far should we go? How widely or how narrowly should we interpret this definition of fraud that will render consent to sex invalid? So what we're talking about here are otherwise consensual sexual encounters, and that's not in dispute in these cases, that this was a consensual encounter, but for the fact that this piece of information was not disclosed by party A to party B. That fact comes to light later, after there's been a sexual encounter, and then the person who feels defrauded because they feel they ought to have known this information can then advance an argument that, well, I didn't really give consent to that sex, even though it seemed so at the time, because you've defrauded me. The court turned to commercial law of fraud, which is interesting, and there's a whole lot that could be said about using and importing a model of commercial law and definitions of fraud in commercial transactions, and imported them into the context of a sexual transaction. But it said, look, we have to have some parameters on using fraud here. If we're going to start convicting people for not disclosing a certain piece of information, then it cannot be that any piece of information that is not disclosed that you later decide you wish you had known at the time is sufficient to start convicting people for sexual assault. That would just be going too far. There was one judge who actually argued for that legal standard, which I think would be atrocious. Fortunately, that position was not accepted. It was explicitly rejected as going far too far. And so what the majority of the court crafted was this test, which has been really the terrain on which we've been fighting this battle of limiting HIV criminalization ever since. And they said there are two things that are needed here. First of all, and this is the crux of the decision, there needs to be a significant risk of serious bodily harm present. So they were clear that not disclosing HIV to your sexual partner, at least in the circumstances that were present in this case, which involve vaginal sex without a condom between a man living with HIV and two female partners over the course of a couple of years. They were clear that that could constitute, in their view, a significant risk of serious bodily harm. They also said that potentially other sexually transmitted infections could meet that standard as well. So on paper, we don't have even an HIV specific or limited to HIV definition of sexual assault in this area, but as we'll see in a moment, it has de facto been almost exclusively people living with HIV who have been prosecuted. Not entirely, but almost. The other thing to note, and this is just a sort of standard point about criminal law, is that the person who is complaining about having been assaulted in this otherwise consensual sexual encounter, the prosecution has to prove beyond a reasonable doubt, the standard criminal standard of proof, that the person who's complaining would not have consented to have sex had they known this person's status. Now, there's an additional twist here that intensifies the criminalization of HIV in Canada, and that is that we have different levels of seriousness of sexual assault in our law. And it goes from basic or simple assault to an assault that causes bodily harm. And then the most serious form of sexual assault is an aggravated sexual assault, which includes wounding or maiming or disfiguring the person who's assaulted or endangering their life. And the court was of the view that the risk of acquisition of HIV would satisfy the requirement of endangerment of life, and therefore not only would this be a sexual assault if there was a significant risk of serious bodily harm, it would in fact be an aggravated sexual assault. Now, that is one of the most serious offenses in our criminal code. It carries a maximum penalty of life in prison. That is not the penalty normally applied, but it is possible. And any conviction for sexual assault will require mandatory designation of that person as a sex offender on the sex offender registry, presumptively for life, but at least for a period of 20 years. So very serious consequences of treating HIV non-disclosure in our law akin to the most violent, horrific kind of rape that our law could envision. That's the equivalence, potentially, that has been drawn. So that was the first case. The mild silver lining, which we continue to try to preserve with mixed results, of this decision in which we intervened, was that the majority of the court said, although they did not need to decide this and they did not decide it definitively on the facts of the case that were before them, they did allow that the careful use of a condom may reduce the risk of transmission of HIV sufficiently so that it is no longer significant. They didn't pronounce definitively on that point, but it was an important concession that we managed to get out of the court. Obviously less than we were hoping for, but it was something. And that suggestion by the Supreme Court of Canada actually was followed by most of the lower courts that in the years subsequent had occasion to deal with the question of, had to deal with sex that was unprotected, was the term we were using at the time, and they were using at the time, or protected. And most of the lower courts were saying, the suggestion that the Supreme Court made about condom use being sufficient, they were taking up that suggestion. So we thought that that position was actually becoming reasonably well established as one important limit on the scope of criminalization. But, as this story will illustrate, the struggle on HIV criminalization is really one of 2 steps forward and a step sideways and 2 steps back and 1 step forward. There's no linear progression often in these things. The issue, of course, returned to court, including to our Supreme Court a number of years later. So 14 years later, there was actually another case in the interim, but it's a relatively minor, obscure point, so I won't get into it. The most important subsequent case came 14 years later, back up to our Supreme Court, and in fact, it was 2 cases heard together. One was the case of a man in a province in the middle of the country who had had sex with multiple women under varying different circumstances. The other case, and that case is called Mabior. The other case called DC, those are the initials of the woman who was accused, was a woman living with HIV in Montreal who had one long-term relationship that turned abusive and eventually was charged as an act of revenge by her abusive ex-spouse or partner when she put an end to the relationship. So very different fact patterns, both raising similar issues, ultimately made their way up to the Supreme Court and were heard jointly. And this was the occasion for the court to potentially reconsider how it was going to understand and define the scope of HIV criminalization for the country. And this time around, there was not only the issue of condom use squarely in front of the court, which it had not been before, but also in the interim, of course, we'd had very significant developments in the science of HIV, including a lot more scientific evidence available by that point about the relationship between someone's viral load and the risk of transmission. So both condoms and viral load were at play in these cases. And in fact, the lower courts, again, agreed with our submissions that either using a condom on its own or having an undetectable viral load on its own should suffice to conclude that there is no significant risk of transmission, and therefore there should be no liability for the fact that you don't disclose, because the court before had said there has to be that significant risk before there's a duty to disclose. And if you don't disclose, then you've engaged in fraud and your partner has not validly consented to sex. So the court, affirmed, and there had been a lot of criticism about the court's earlier decision, about how it left too many questions unanswered, it was too broad, it was vague. And so the court considered a whole slew of different approaches that were put before it, including those that we put before it, about how to appropriately limit criminalization. And unfortunately, kind of screwed it up again, notwithstanding our best efforts. Although, as we will see, it may not be 100% the doom and gloom situation that we thought it was when the decision first came out. What the court did this time was it reaffirmed, because courts don't like to second guess themselves or contradict themselves too quickly and say, oh yeah, we got it wrong before. It's not usually what they want to do, especially if they're the Supreme Court of the country. So they said, no, we reaffirm our significant risk of serious bodily harm test from before. That's still the valid test. We're going to reinterpret it somehow and say that what that means specifically in the context of HIV is that there is a realistic possibility of transmission. So now the new phrase is realistic possibility of transmission, which in their minds, or at least in their judgment, is the same thing as saying there's a significant risk. I actually think those are different standards, to be honest. I think something being realistically possible is a lower threshold than something actually being a significant risk. We can debate that. However, the most significant thing in the judgment was how they then dealt with these issues of condoms and viral load. And again, this was a circumstance where what was at issue in both cases was penile vaginal sex only. So no discussion of oral sex, anal sex wasn't at issue. But the question was squarely before the court this time about whether either condoms or an undetectable viral load, as we framed it at the time, would suffice. And the court basically mostly said no, neither one of those is sufficient on its own. However, they did leave the door open a little bit, and this is really important. What they said is, we will accept that there is no realistic possibility of transmitting HIV if a person has a low viral load, and note that they use the term low, not undetectable, and a condom was used for penetrative sex. If those two things are present, what Edwin, I think, has very helpfully often described as having both a belt and suspenders, then we are satisfied that there is no realistic possibility of transmission. It's really, really important for us to not fall into the trap of assuming that that means that that's the only way that the court has said you can negate the existence of a realistic possibility of transmission. But at least in this case, they said, we are satisfied that both of those things are required. And so they unfortunately rejected the argument that some of the charges that Mr. Mabior was facing, where condoms had been used, but he had a detectable viral load, that he shouldn't be convicted for those. And they rejected the argument that an undetectable viral load on its own would suffice. Now, they left the door open to the law possibly evolving in its standard depending on developments in treatment. And they referred specifically to treatment, which is good and bad. Good in that it leaves open what has happened since, which is more developments on the viral load line of argumentation. But their treatment of the condom issue was atrocious, frankly, and doesn't seem to, on the face of the judgment, leave us the same sort of wiggle room with respect to arguing in subsequent cases that condoms might suffice, which is particularly galling, I might add, because a majority of the court 14 years before had said either, we think condoms may well suffice, and some of them actually even went further, including the Chief Justice, who wrote this decision, subsequent decision for unanimous court, that in her view, we should have a bright line test and that condoms absolutely would suffice. And yet here she wrote 14 years later something that directly contradicts that. Go figure. But what they did allow was that in the case of a low viral load, which they defined as being under 1,500 copies of the virus per milliliter, taken from the HPTN 052 study, which was in front of them, they didn't set the bar quite so high or low, I guess, depending on your perspective, as having an undetectable viral load. They would allow that if there was a low viral load. Now, that may be a distinction without that much of a difference, to be honest. Again, you take your small victories where you find them. So there were questions that remained here. What about oral sex? It wasn't addressed by the court. We had asked the court to specifically say oral sex does not pose enough of a risk to constitute an aggravated sexual assault if you don't disclose. They didn't address that question. Fortunately, we haven't seen that many prosecutions for just oral sex, although there have been a couple. And we can talk about those if people are interested. But it left open this question of condoms or viral load. Do you need both? Will one or the other suffice? So I just want to paint a picture for you of how this has played out to date since the beginning of HIV criminalization in Canada, now that you understand a little bit the legal framework within which we're operating. So as of just over a year ago, which is the last time we did a comprehensive breakdown of all the cases, there had been at least 184 people in Canada charged for HIV non-disclosure in 200 prosecutions. So if you do the math, you can see that a few of the people had been charged in more than one prosecution. The majority of the cases are against men who have HIV who have sex with women. However, there has been an increasing number of gay men and other men who have sex with men who have been prosecuted. And similarly, there's been a steady proportion of prosecutions against women living with HIV, all of whom are charged for relations with male sexual partners. I think I mentioned before in response to a question yesterday that among the women who have been prosecuted, it's disproportionately Indigenous women, often with various socioeconomic marginalization factors at play in their lives, who have been prosecuted. And among the men who have been prosecuted, it appears that black men have been disproportionately prosecuted, and certainly those prosecutions have been disproportionately covered in the media. And almost all of the prosecutions that we have seen under this legal frame have been for HIV non-disclosure. There is a small handful of prosecutions for not disclosing some other STI, like herpes or hepatitis C, although we don't often think of hepatitis C as a sexually transmissible infection. It can be in some circumstances. This is the timeline. You don't need to look at all the data, but basically to show you that in the early years, there were just a few cases across the country each year. Then there was a significant increase after that first Supreme Court of Canada decision that had clarified the legal pathway that prosecutors could take to get a conviction for an aggravated sexual assault. We saw another subsequent jump around the time of the second court case, but interestingly, we've seen some declines since then, although still a troubling number of prosecutions and in troublingly overly broad circumstances. You probably, I'm afraid, can't see the small text, and I copied this from other researchers' work, so I can't actually make it any bigger, I'm sorry. But it shows you the breakdown by race or ethnicity of the people who have been charged, and you see that basically white people and black people are the two largest racial or ethnic groups that have faced prosecution in Canada. The prosecutions, so the red here is the media coverage of prosecutions by race and ethnicity, and you will see here the red part of the pie chart is where the accused person is black, mostly black men, and there has been disproportionate media coverage of those prosecutions. So that tells you something about what's going on in the ambiance about HIV criminalization and the way it interacts with other kinds of discrimination. This is just a breakdown of the sexual orientation among the men who have been charged, and you will see that at this point, approximately a quarter of the men who have been charged are men who have male sexual partners. So that number has steadily increased. What about how these cases get handled by the courts and by prosecutors? So in those cases where we know the HIV status of the person who is complaining of having been sexually assaulted, which we don't necessarily have that HIV status information for every single one of them. Most of the prosecutions where we know that information have been for exposure, not actual transmission of the virus, but where the person who is the complainant is HIV negative but has been exposed to a risk or what they perceive to be a risk of acquiring HIV. A very large majority of the cases in which charges are laid end in conviction, and it's instructive, I think, to note if you look at the conviction rate for other kinds of sexual assault prosecutions, it's much lower. But when we have HIV non-disclosure sexual assault prosecutions, it's much higher. Now, there could be various reasons for that, but I would suggest that there is at least some basis to think that HIV stigma is operating in the criminal justice system when it produces that kind of disparity in conviction rates. And when you look at sentencing in these cases, the sentences on average that have been imposed for sexual assault convictions dealing with HIV non-disclosure, as opposed to other kinds of what we normally understand to be sexual assault prosecutions, there is harsher sentencing in the HIV non-disclosure cases. Let me just skip over these graphs or these charts in the interest of time and just jump to this one here. So sentencing in HIV non-disclosure, more than 90% of the cases where there has been conviction, you see a prison sentence imposed. And the length of the sentence is on average about 54 months. Now, I add the caveat that it's tricky to do comparisons about sentencing because sentencing, of course, is very fact-specific in every case. There are all sorts of factors at play in every case, or at least there ought to be, to determine what the appropriate sentence is. And so we need to take this one with a grain of salt. But overall, if you look at average length of sentence for non-HIV sexual assault cases versus HIV sexual assault cases, the sentence in more than 70% of the cases of HIV non-disclosure, the person who was convicted is sentenced to more than 2 years in prison. I said it was, the average is 54 months. That's more than double the average sentence for other sexual assault sentences, which is about 24 months. Again, I suggest there's something operating here in the criminal justice system, and I think we can call it HIV stigma. So what to do about all that? We heard a little bit yesterday about the task of bringing science to justice, because as you will have seen from my overview of the legal environment, the question of risk is central here to where the lines get drawn by the criminal justice system. Given that our Supreme Court said there has to be a significant risk, later defined as a realistic possibility of transmission, much of the battleground then is about where the criminal justice system is going to find that there is or is not a significant risk or a realistic possibility of transmission. And mention was made yesterday of the Canadian consensus statement by scientists, which was developed following that second Supreme Court decision, specifically because of the concern that the court had got it wrong when it came to its approach to condoms and viral load. And other things, but that was the main concern. And so nearly 80 of the leading scientists in Canada put out a consensus statement that was published in a peer-reviewed journal saying, we're concerned about the criminal justice system's inability to appreciate the science properly here, and it is leading to overly broad application of the criminal law. Now, really importantly, they were very clear to say, we're not issuing a public health statement here, we're not issuing you advice in our description of risks associated with various activities. What we're doing is speaking directly to the criminal justice system in terms that we hope it will understand in applying a legal standard in individual cases. This is not broad public health advice. And so you heard yesterday that they recrafted or recharacterized the degree of risk associated with various acts. And they said at the highest level, there is a low possibility of transmitting HIV through a given sexual act. So the things that we normally think of as high risk and that public health educators have usually talked about as being high risk activities are in fact on a per act basis there's a low statistical possibility of transmitting HIV through that act. So vaginal sex without a condom where the male penetrative partner has HIV. That is a low possibility per act of transmitting HIV. And the reason that they did that is because one single act is sufficient to criminally convict someone under the law as it has been stated. And so they felt it was important to speak to individual per act risks. So it goes from low possibility at the highest down to no possibility. And they defined what each of these categories mean and then applied them to different sexual activities under different circumstances. And I've just given you the summary table here that is in the consensus statement, but you'll see that they've said, for example, vaginal penile sex where there is no condom is a low risk, that's the high water mark. If there is a condom, they said there's a negligible risk of transmission, although very importantly, they also said, look, if the condom isn't broken and has been used properly, then HIV will not pass through that latex barrier, and so you have 100% protection and the risk is effectively zero. And similarly, they said if someone is on effective antiretroviral treatment, the risk is negligible. And so they did a similar sort of exercise for other activities. I won't go through them all. Since that consensus statement came out in 2014, of course, there has been a broader global consensus emerging, the U=U consensus, that more or less adopts a similar approach and talks about risks being negligible to non-existent when someone has an undetectable viral load. And note the definition of undetectable viral load here at the bottom, and that is under 200 copies per milliliter. In many cases, up until this point, we've often talked about undetectability, depending on which test is being used, as being 40 or 50 copies per milliliter. But in fact, based on the science, this consensus statement is saying under 200 we'll treat as undetectable, and there's negligible to no risk of transmission in such circumstances. Mention was made yesterday of a forthcoming global scientific consensus statement, which I think will continue to build on this, which I think will be important, and it is the scientific developments have finally started to have some impact in Canada. So I'm going to go back to the law, and I will wrap up very shortly, I promise. So I mentioned that condoms and viral load were at issue in the second case that the Supreme Court dealt with. And it was interesting to see that although the Supreme Court in that case was very conservative, too conservative in our view, a number of lower courts have also been similarly critical of the too conservative approach that the Supreme Court took. And they have actually found and exploited some of the wiggle room that was left, at least with respect to the viral load question, in that Supreme Court decision. That hasn't always been the case, and in the immediate aftermath of that decision, unfortunately, we did have some courts and prosecutors who were quite emboldened and encouraged and reassured that their very aggressive approach to prosecuting people and convicting them was in fact warranted and had just been given a stamp of approval by the Supreme Court of Canada. And they will say that to you explicitly. Well, we're just doing what the Supreme Court said. That's literally what they say to us when we say, well, maybe you should be a little more restrained. So we actually had a Court of Appeal decision in the province of Ontario, the largest province, which is where I live, and which accounts for more than 50% of the prosecutions to date, that said, okay, we've got a case in front of us where the prosecution has established that no condom was used and the accused guy didn't disclose. His viral load is irrelevant, is what the court said. I think that's clearly wrong. But that's what they said in interpreting the Supreme Court's decision, because they said, well, the Supreme Court said you have to have both condoms and a low viral load. So there's no evidence in front of us here about the viral load. We're just going to presume that because he has not brought forward evidence to show that he has an undetectable viral load, end of story. And that conviction was upheld. And there have been a significant number of prosecutions where someone was prosecuted, 9 out of 10 of these cases were in Ontario, where the person had a low or an undetectable viral load, notwithstanding that we have the science to suggest otherwise, that there is no significant risk or no realistic possibility of transmission in those cases. However, there has been a little bit of a silver lining. More recently, in the very same province, we have seen cases where prosecutors have withdrawn charges or reduced charges when confronted by equipped defense counsel with the appropriate science and expert reports from scientists. And we have also seen a number of lower courts that have been critical of the Supreme Court and have said, well, we don't actually think it means what maybe you thought it means. We have concluded that in every case, we have to decide, was there a realistic possibility of transmission? And the evidence that I have in front of me as a judge in this case from the medical expert that was brought forward by the defense, or sometimes even by the Crown, the prosecution, that it establishes that there is no realistic possibility, or there wasn't in this encounter, because of the person having a low or an undetectable viral load. And we have at least 3 cases now where that line has started to emerge, which is encouraging, suggesting that, in fact, a lower undetectable viral load is perhaps established as a defense now, or will be increasingly. What is left uncertain is the condom question. And this is my last slide. We do have now some movement happening from both our federal government and some provincial governments to actually finally provide some recommendations or guidance to prosecutors that says we won't prosecute people if they have a suppressed viral load, so under 200 copies per milliliter. We have been fighting for prosecutorial guidance that says that, plus many more things, for some time in some of the provinces, and we finally achieved that small step forward in one of them, the one that's most zealous to date in its prosecutions. But I feel like we're setting the stage for actually going further, and we need to build on the case law that exists and the science now to establish not just a viral load defense, if I can use that shorthand, but also a condom defense, that a condom alone will suffice. There are other things, of course, that we need to see in our guidance and more limits on our law, but at least those things are top priorities for advocacy. And I will save the remarks for later, maybe in the Q&A about some of the lessons that might be learned, but I did just want to draw to your attention a resource kit that is on our website, aidslaw.ca, that has already been mentioned earlier. It's a bilingual resource kit, which I underline for people because I know there are a good number of Francophone colleagues in the room. And you can find there a lot of scientific material, key cases, and some films that may be of interest to you, the links for which I've put here. But do also absolutely go to the HIV Justice Worldwide's toolkit on HIV criminalisation, because it's even more comprehensive and up to date, and it's a fantastic resource for you. So I will stop there and just leave some acknowledgements on the screen. Thank you.